The next case on the call of the docket is agenda number 2, number 125945, Pico, State of Illinois versus Crossetti Brand. Mr. Bennick, you may proceed.
Good morning, Your Honors. My name is Joseph Bennock of the Office of the State Appellate Defender, and I'm here on behalf of my client, Crossetti Brand. The appellate court ruled that Mr. Brand's case must be remanded for a Krenkel hearing, but otherwise affirmed his convictions and sentence. This court granted leave to appeal on two issues: whether the state properly authenticated 2 Facebook messages that were admitted against Brand, and whether the state proved beyond a reasonable doubt that Brand committed possession of a stolen motor vehicle. As to the Facebook messages, the court allowed the state to present evidence regarding 2 messages that Brand allegedly sent to the complainant, one from November 8th and one from November 21st. According to the complainant, the November 8th message told her where she could find her car, which she claimed Brand had stolen during the incident at her apartment on November 3rd. A screenshot of that message was not admitted into evidence because the complainant claimed that she had deleted it due to her inbox being full. The November 21st message allegedly contained threats against the complainant and her family. A screenshot of that message was entered into evidence. However, these messages were not properly authenticated. The state has not pointed to a single case in which a social media communication was found to be authenticated based on the meager showing presented here. According to the complainant, the messages at issue were sent from an account with the name Massetti Meach. The screenshot of the November 21st message does not display the profile picture associated with that account, or the date that it was sent, or even the name of the sender or the recipient. In addition, the state failed to present any other messages that may have been exchanged between the 2 accounts. It also failed to establish what kind of device was used to send the message, whether it was a cell phone, a computer, or a tablet. There's actually nothing on the messages that indicate that they are a Facebook message as opposed to a text message or a message from another social media service. This showing was insufficient to authenticate the messages and justify their admission. Owing to their digital nature, the authentication of social media communications presents unique concerns in terms of authentication. In Kent, the appellate court laid out these concerns, observing that almost anyone can create a fictitious account and masquerade under another person's name, or can gain access to another's account by attaining the user's username and password. And more recently, the Vermont Supreme Court noted that it's not only theoretically possible for a person to set up a social media account purporting to belong to someone else, it is relatively common. By November of 2019, Facebook had removed more than 5 billion fake accounts, which was up from 3.3 billion in 2018.
Counsel, isn't there a qualitative difference though between a public Facebook post and communication between 2 individuals via text message, email, instant messenger, or similar forms of communication?
Yes, the messages at issue here were purported to be private messages between one account and another account, whereas a Facebook post would be something that would then be posted on the person's Facebook wall, basically, so that any person could then, who is friends with that person, could then see that post, basically, and scroll down. But analytically, they present the same concerns, which is that somebody could be gaining access to another person's Facebook account, or that somebody could create a fake Facebook account and make posts or send messages purporting to be somebody else. Essentially, they both present the opportunity for somebody to masquerade as somebody else, or to send fake message, to gain unauthorized access to the account of another. And that's why those 2 considerations need to be taken into account in almost every case that deals with social media communications. The 2 considerations being whether the purported author actually controlled the account from which the message was sent, whether it's actually their account, and whether there's actually any evidence that they actually authored the message.
Counsel, I don't think defendant disputed that this is how he communicated, or deny this, did he?
He did not deny, he didn't testify at trial, so there was no evidence on that point either way. But just to illustrate the sort of the difference between the control of the account and the actual sending of the messages, in People v. Curry, the state sought to, in Illinois appellate court, the state sought to admit certain Facebook messages that the defendant allegedly sent. And the state obtained a search warrant and sent it to Facebook for information associated with the defendant's account. And in response, Facebook sent a certificate of authenticity with the messages at issue, as well as the name, address, telephone number, and email address associated with the account. And the court found that this information was sufficient to show that the defendant did control the account. In other words, where the messages came from and where they went to, but that it was absent evidence that the defendant actually authored the messages, insufficient to show that he actually sent them. The lesson of Curry is that simply showing that a message originated from a defendant's account is not on its own sufficient to admit the content of those messages.
Well, there's some indication that the messages contain information only the defendant would know, correct?
That's the argument that the state makes in regard to the fact that Brand allegedly actually did send these messages. The state says that because they make several arguments in that respect. The first is that because the November 8th message allegedly told the complainant where she could find her car, which is information that the state says that only Brand, as the person who took the car, would know. They say that it was authenticated by that information. But whether Brand took the complainant's car is the very fact that the November 8th message was admitted in order to prove. The state's position erroneously starts from the assumption that Brand was, in fact, responsible for the theft of the complainant's car. Essentially, the state is asserting that, one, we know Brand took the complainant's car because he sent the Facebook message, and two, we know that he sent the message because he took the car. It's a circular argument, and it was rejected by the appellate court in Kent. There, the defendant was accused of shooting a man and leaving him to die in his driveway, and a Facebook post was admitted against him that was in his name with his account and with his profile picture that said, "It's my way or the highway, leave him dead in his driveway." And the Kent court, the state argued that it was authenticated because the victim was in fact shot and left for dead in the driveway. But the Kent court characterized that argument as circular and rejected it. It said the statement, "leave him dead in his driveway," was not self-authenticated by the fact that the victim was killed in his driveway. The state's reasoning that this post can be attributed to the defendant because it is incriminating is circular. To the extent that this information is obscure, it would be known by the offender, not necessarily by the defendant. And here, the state's argument is no less circular. And indeed, accepting the state's position would open the door to the admission of essentially any social media communication. Because in every case in which the state seeks to admit such a communication, it's going to be because it references the charged offense in some way.
What about the fact that they found the keys or the fob on the defendant when they arrested him?
They did find that was testimony that was admitted at trial, but the appellate court on appeal found that the state had failed to establish a chain of custody for those keys that were found allegedly found on Mr. Brand. The state didn't present the officer who actually performed this custodial search or allegedly performed this custodial search of Mr. Brand. So there was no proper chain of custody for those keys. We don't really have any idea how they, based on the appellate court's ruling, no idea how they actually, ended up in the state's possession.
Is it your position that social media should be treated differently than other documentary evidence?
It's my position that Rule 901 should govern the admission of social media communication. And that requires the proponent to present a showing sufficient evidence to show that the matter or that the document in question is what they claim it to be. And that can be applied to social media. But in the same way that, a sufficient showing is going to differ based on the nature of the medium. There's a different sufficient showing for a letter, and a different sufficient showing for laying a foundation for a phone call. any analysis of what a sufficient showing is for social media communication does need to take into account those features and those aspects of social media that I've identified, and that make it particularly susceptible to masquerading as somebody else and to gaining unauthorized access to another person's account.
Is the standard review in this case, it's abuse of discretion?
Correct, Your Honor.
So this is not a de novo.
Correct, Your Honor.
Counsel, regarding your circular reasoning argument, isn't there independent evidence in this case that the defendant took the account, independent from the communications, and that is the testimony of the victim? That again, the state made a prima facie case regarding from the testimony of the victim that the defendant took the car, which then verifies the contents of the email.
It's correct that the complainant did claim that Mr. Brand took her car during this incident at her apartment, but again, that's going to be pretty much in any case in which we're talking about the admission of a social media communication. There's going to be it's going to be the case that it references the charged offense in some way, that there's some tying into the offense that the defendant is accused of committing. And so if that is enough, if the state can just point to and say, well, she says he took his car, or there's this slight other evidence showing that, he may have authored this message, it's going to open the door to basically, it would allow for the admission of essentially any social media communication. In a circumstance like that, it would sort of do away with the court's gatekeeping role and the purpose of 901, which is to screen for and to prevent the admission of these, what can potentially be highly prejudicial, evidence and communications purportedly authored by the defendant.
Well, the victim here had received communication before from this Maceda Beach.
That is what she said, but there was absolutely, no evidence that they had ever, other than that they had ever communicated before.
But that was evidence in the record that she testified.
She did say that she had communicated with Mr. Brand under this Maceda Beach account before.
From this account.
Yes. But no case has ever found a social media communication authenticated, or even that a defendant, was in possession or control of an account just based on one witness's sort of uncorroborated testimony. Here we don't have any other messages that were exchanged between the two accounts. In most other cases where courts have found messages to be authenticated, it's because the state presented multiple messages showing a sort of, a response, and there's usually contextual clues within those messages that can be then used to sort of discern or glean the identity of the sender. Here, we don't have anything. We don't have anything even close to what they presented in Curry or in Kent, or even in cases where they have not found messages to be authenticated.
But like in those cases, especially in Kent, there was an indication those are only examples. There can be all kinds of examples to justify a rational basis for a foundation to justify the introduction of that.
Correct. There is
circumstantial evidence.
Yes, there can be circumstantial evidence, definitely. And I'm in no way intending to suggest that the state needs to conclusively establish beyond a reasonable doubt, the identity of the person who sent these messages. But what they need to do is present more evidence than what they presented here, which is just a single screenshot of one message and the complainant's claim that, I've discussed this with Matt, I've just messaged him on Facebook before using this account. No court in any other state or at the federal level has found such a low showing to justify the admission of messages.
I thought earlier you were suggesting that in order to have sufficient authentication, you need some kind of an authentication certificate from Facebook. Are you saying that's not the case, or?
No, that would certainly go a long way towards showing that, obviously that would, help to establish that the defendant, that this was his account. If you could get a certificate of authenticity from Facebook saying, this account to use this case as an example, if the state sends send a subpoena to Facebook and Facebook responds, well, this Massetti Meach account was set up by, Crosetti Brand at this address and was used with this email address to set it up, that would certainly be very powerful evidence that Mr. Brand controlled the Massetti Breach account. But as Curry shows, and as other federal cases and other state cases from Illinois have shown, that wouldn't necessarily be enough to show that Mr. Brand actually sent the messages at issue, because of the possibility that somebody else could have gained access to his account in a number of ways. People share passwords for Facebook accounts all the time. Facebook has different security features that can make, so if you choose to stay signed in on your Facebook account, like say you use the computer at the library or in any sort of public setting, any person who uses that computer after you and pulls up Facebook, your account and all of your account information is going to be there and be available to them. And people can guess passwords, and there's all sorts of possibilities for gaining access to other people's accounts, which is why courts have taken pains to point out the need to scrutinize these type of communications very closely.
So what is the rule you would like us to enunciate? Can you articulate that for me?
The rule that I would like for you to enunciate is that under Rule 901, a matter sufficient, to be what the proponent claims it to be, needs to take into account both whether the account belongs to the purported sender and whether there's any evidence that the purported sender actually sent the messages at issue. That those would be the two considerations that courts would look to and really scrutinize closely when analyzing the admission of social media communications, whether they be Facebook or any other sort of social media service.
And both would have to be fulfilled.
In most cases, yes, but there's certainly a stronger showing as to one could certainly compensate for deficiencies in the other. For instance, if you could if you could trace the message through an IP address or a search warrant issued to a cell provider to to a person's personal cell phone, at that point, even if you don't have proof that it's their account, I think that would be sufficient to justify the admission of the message, if you could trace it to their personal cell phone. And then at that point, if they, at trial, it'd become a matter of weight. If they have any evidence that, hey, somebody stole my phone on the day in question, at that point, that would be the appropriate venue for that. But again, we're so far removed from any sort of specific evidence like that in this case. Here, this issue is fully preserved. And so the issue is whether or not the erroneously admitted messages contributed to Brand's conviction. Here, the court was responsible for the decision to admit the messages, and therefore it cannot be said that it did not consider them in finding Brand guilty. Indeed, in regard to the PSMV charge in particular, the court explicitly relied on it in finding Brand guilty. And moreover, what the court's statements in finding Brand guilty, it said that this case was entirely about credibility. And certainly the improperly admitted Facebook messages helped to bolster the complainant's credibility by corroborating her testimony. And during closing arguments, the state relied extensively on the messages for this very purpose. As to the November 8th message, it said it was strong circumstantial evidence. And as to the November 21st message, it argued that the alleged threats contained in the message actually constituted an admission of guilt by Brand. So this is highly prejudicial evidence. And critically, the court already had doubts about the complainant's testimony, as evidenced by its finding that her and her son's testimony failed to establish that Brand had a firearm. They both testified extensively about a firearm, but there were so many contradictions between their testimony that the court found that the state had failed to prove that element beyond a reasonable doubt. Accordingly, the erroneous admissions of the messages was not harmless error, as they served to bolster the complainant's credibility, which was the critical issue in this case. Alternatively, even if this court finds that this issue is forfeited, it may review it as first-pronged plain error because, as discussed, due to the inconsistencies in her testimony, the evidence at trial was closely balanced. Brand therefore respectfully requests that this court reverse his convictions for home invasion for PSMV and remand for a new trial. And just briefly as to the second issue, The state contends that they were not required to show an intent to permanently deprive because Brand was charged with possession of a converted motor vehicle as opposed to just a stolen motor vehicle. However, the IPI 23.36 directs that Mr. Brand respectfully requests that this court reverse his conviction for PSMV because the state failed to prove beyond a reasonable doubt that he took the complainant's car with the intention of permanently depriving her of its use. Thank you, Your Honor.
Thank you, Mr. Bennett. Mr. Sonnenfeld?
May it please the Court, Assistant Attorney General Robert Sonnenfeld for the people. This Court should affirm the convictions and sentence of the defendant because neither the evidence authentication issue nor the sufficiency of the evidence claim raised warrant relief. With respect to the authentication issue, this Court can affirm on any of three bases. First, the defendant failed to preserve this evidence authentication claim. Second, even if this court were to find that this issue was preserved, the trial court did not abuse its discretion in finding the evidence properly authenticated. And third, even if this court does find that the trial court did abuse its discretion, any error was harmless. Now, briefly, with respect to the forfeiture issue, we rely on the arguments raised in our brief that the defendant failed to properly object, failed to raise the issue in a motion for new trial. And so we rely on those arguments, and I'm happy to answer any questions that this court may have with respect to that. But we intend to, our argument will focus mainly on the substantive issue because even if this court were to find that the issue was preserved, the trial court did not abuse its discretion in finding the evidence authenticated. And I think importantly, it's important first to kind of reorient the court back to what the authentication standard that is applicable here is. And that standard, under Rule 901, requires that a proponent need only present evidence sufficient to support a finding that a piece of evidence is what its proponent claims. In conducting that analysis, a trial court looks at all of the evidence in favor of authentication, in the light most favorable to the proponent, and it considers all that evidence in its totality. Now, defendant correctly concedes that the Facebook messages at issue here are documentary evidence. And so for the state to have authenticated these messages as documentary evidence, the state only needed to prove a rational basis upon which the fact finder may conclude that the exhibits belonged to the defendant. So importantly, the trial court, in conducting that analysis, engages only in a gatekeeping function, a screening function. The ultimate issue of actual authorship or whether that piece of evidence was sent by or authored by the defendant is ultimately up to the trier of fact. So contrary to the defendant's claims, there still is that safeguard, and the defendant could have raised any issues he had with respect to the authenticity of those exhibits to the trier of fact. So nothing prevents him from presenting that argument. Now here, defendant uses much of his argument to claim that due to purported unique susceptibilities to fabrication and fraud that are associated with social media messages, social media profiles, that a new rule should be applied, one that is more stringent, one that requires the state to prove that the defendant authored the messages and sent the messages. There are a couple responses to that. First, at a very basic level, that's exactly what the authentication standard provides already. The trial court, in conducting its authentication analysis, considers all of the evidence and determines whether, under the totality of the evidence presented, in the light most favorable to the proponent, the evidence can be deemed such that a trier of fact could find that the evidence was authored and sent by the defendant. That the trial court already engages in that analysis. And again, it's up to the trier of fact to ultimately determine whether the evidence was in fact authored and sent by the defendant. But beyond that, the reliability concerns that the defendant speaks about, these concerns about falsification and fraud, none of these concerns are unique to social media messages. Illinois courts have long considered these potential concerns with respect to documentary evidence and reliably engaged in the Rule 901 analysis to find evidence properly authenticated when the evidence is sufficient to show to show a rational basis for a trier of fact to find that the evidence was is what its proponent claims it to be. Courts have considered these reliability concerns in considering things like notes, things like text messages, things like emails, and they've all reliably applied that analysis and found the evidence properly authenticated when the evidence permits it.
Counsel, does the holding in Kent shed any light on that analysis?
It does. So in Kent, defendant notes that there was not sufficient evidence to authenticate the messages there because of particular reliability concerns. Now, the evidence that was presented in Kent, the issue there in Kent was that the evidence that was presented contained no direct link whatsoever. There was no evidence linking the defendant to the Facebook profile at issue. There was no claim that the name on the Facebook profile was in any way affiliated with the defendant. There was direct testimony that other individuals had come to the scene of the crime, and so there was direct evidence in the record suggesting that individuals had been at the crime scene and had knowledge of the crime scene and could have posted about it after the fact. Kent is completely distinguishable to our case. What we have here is we have direct evidence from the victim testifying that in her prior experience, her own personal experience, she communicated with the defendant via Facebook Messenger in the past. She noticed that defendant used the name Massetti Meach, this very same profile, when defendant did so. She testified that these messages bore the name Massetti Meach, and she testified that based upon her prior experience, based upon her prior communications with the defendant, she knew that the defendant sent these messages. And then briefly, with respect to this allegation that others could have known of the attack at the victim's apartment, could have known of the potential taking of the victim's vehicle. Again, this is distinguishable from Kent because in Kent there was direct testimony showing that there were individuals who had approached the scene. There's nothing in the record in this case indicating that anyone other than the defendant and the victim, the people in the apartment, knew of the events that were contained in these messages.
Counsel, what about opposing counsel's argument that this is just circular reasoning?
It's not circular reasoning, Your Honor, because again, as in Kent, there was no testimony directly linking the defendant to the Facebook post in that case. So, the defendant is claiming that Kent says, well, the only person who would know kind of the events that were contained in the message is the perpetrator because there was no evidence that the defendant sent the messages. Here, for the reasons I stated, the victim provided that direct link between defendant and the Facebook messages here. She testified that defendant used the Massetti Meach account and that based upon her communications with him in the past using that account, she knew that defendant used these messages. So Kent is distinguishable because we have that direct link, and the trial court was clearly within its ability to find that testimony credible and did find that testimony credible in authenticating these messages. But beyond the victim's testimony, we have circumstantial evidence which further shows that that these messages were properly authenticated. This circumstantial evidence includes things like the distinctive characteristics of the message. It includes the context around which the messages were sent. It includes the information contained therein. As we mentioned, the November 8th message contained the references to the taking of the vehicle, which defendant was in the unique position to know as the person who took the vehicle. There was testimony that the victim, after her apartment was broken into, the defendant took her keys from the bedroom, immediately left the apartment. The defendant went to the window, looked outside, saw that her car was no longer in the spot that she normally placed it. She found the car at the location that these messages referred to, at that exact location, and her keys were returned to her after the defendant was arrested and searched. With respect to the November 21st message, there are distinctive characteristics in that the defendant, as the individual who dated the victim for a period of 2 years, contained information that an individual in that situation would have known. He specifically referenced various streets that the victim's family members lived on and threatened those family members. The message correctly alluded to MB's age of 15 by stating therein that he would not live to see 16. And then beyond that, I mean, just the circumstances surrounding the sending of the message. These messages were sent mere days after the victim broke up with the defendant, mere days after the defendant had broken into the apartment and attacked her. The November 21st message specifically threatened MB, victim's son, who was the only one of the victim's 4 children at the apartment that night, to have confronted the defendant. And then lastly, I mean, just after having sent this message containing threats which referenced the streets, the victim saw the defendant walking outside of her brother's apartment complex on the very street that was referenced therein, containing the threats against her family members.
You know, the other side is suggesting that for the social media to be able to authenticate and lay a foundation, you have to show that they actually controlled the account in some way, and they actually sent the message. But the implication, it appears from their argument, is that to do that, we should require that that the proponent of the evidence negate other possibilities of fraud or wrongdoing or someone else using the account. I almost think, if my memory serves me correctly, there was a suggestion that even the victim could have made this up and sent this. So would that be required to authenticate and lay a foundation that you negate the possibility that this is fraudulent or some other person? In other words, you go beyond the normal things in introduction of evidence and laying a foundation.
Absolutely not, Your Honor. As I mentioned earlier, so on a basic level, Rule 901 only requires a rational basis to show that a piece of evidence is what its proponent claims that it came from the defendant. And the trial court is free to take any of that evidence in support of authentication. What defendant is arguing is something that is wholly above what is required by Rule 901 and the general authentication standards here. The state is not required to disprove any and every alternate potential sources of this evidence. All that is required of the state is a rational base to put forth evidence that supports a rational basis that defendant sent these messages. And the state absolutely did that here via testimony of the victim and the circumstances surrounding the sending of the messages and the contents of the messages.
Well, yeah, the defendant certainly suggests there's a possibility of potential abuse in this media, in this social media, that there are all kinds of other possibilities that could have happened, correct?
That's correct. And we don't, the ultimate issue of authentication clearly is up to the trier of fact. That's the baseline kind of. The trial court acts only as a gatekeeper, so it's the trier of fact which makes the ultimate determination. But beyond that, as I mentioned earlier, the reliability concerns associated with social media messages, it's nothing that is not already considered by courts in dealing with other types of evidence, whether it's a note found on a street, whether it's a text message, whether it's an email. All of these pieces of documentary evidence undergo the same authentication analysis, and so there's no precedent, there's nothing indicating, or nothing that indicates that social media messages should be considered any differently.
If in the court, when the court's determining what the proper basis should be for foundation and making this saying it's authentic, these other pieces of possibilities could also be introduced in the evidence, could they not, as attacking that document that information that was admitted?
If I'm understanding Your Honor's question correctly, the defendant certainly can contest, after the authentication determination has been made, the defendant can certainly contest the genuineness of the ultimate genuineness of the piece of evidence at trial before the trier of fact. So it's important to remember that the trial court engages only as that gatekeeping screening function, and the bar for authentication is very flexible and very low. And the trial court heard the evidence here that was presented, and it found the victim's testimony credible. It found the evidence contained in the assertions contained in the messages sufficient enough to warrant authentication of these messages here. And so because there's nothing to suggest that anything more is required for the authentication of these messages, the state only needed to prove a rational basis that defendant sent these messages, and the state did so. Turning briefly to the defendant's second point, the evidence was sufficient to convict the defendant of a violation of Section 4-103A1 for possession of a stolen or converted motor vehicle. So importantly, the people were not required to prove that the defendant had an intent to permanently deprive the victim of her vehicle. Section 4-103A1 provides that it's a violation for a person not entitled to the possession of a vehicle to possess it, knowing it to have been stolen or converted. And as this court is well aware, the primary goal is to effectuate the intent of the legislature, and to do so, it looks to the plain language of the statute. Here, Section 4-103A1 uses the phrase stolen or converted in the disjunctive. And so the state could pursue either of two distinct legal theories in finding the defendant guilty of the section. It could prove that defendant possessed the vehicle knowing it was stolen, or possessed it knowing that it was converted. Certainly, there are some instances in which an intent to permanently deprive may be necessary, but those circumstances are limited to situations in which the defendant is charged specifically with possession of a vehicle with intent to permanently, possession of a stolen motor vehicle, and where the prosecution injects that issue into the trial, specifically claims that the defendant stole the vehicle. None of that is applicable here. Here, the defendant was charged with possession of a stolen or converted motor vehicle. There was no allegation by the prosecutor specifically that the victim had stolen the vehicle. The evidence that was presented was in support of a theory that the defendant had converted the vehicle. And sufficient evidence was presented there. The evidence was that the defendant broke into the victim's apartment, took the victim's keys, immediately left. The victim looked out the window, her car was gone. She received messages several days later showing where the car was. She went there, found it, and her keys were returned to her after the defendant was arrested and searched. So the trial court, taking all of this evidence and viewing it in the light most favorably to the prosecution, it could reasonably find the defendant knowingly converted the motor vehicle, which requires only a knowing wrongful deprivation of the vehicle. And because that evidence was sufficient, this point warrants no relief. Unless this court has any additional questions, we ask that this court affirm the convictions and sentence of the defendant. Thank you. Thank you.
Thank you, Mr. Sonnenfeld. Mr. Bennett, you can proceed.
In regard to the state's point about the failure to preserve this issue, the appellate court correctly found that this issue was fully preserved. Defense counsel objected to both messages at trial and in a post-trial motion. In People v. Hyder, this court stated that the purpose of the forfeiture rule is to ensure that the trial court had an opportunity to review the same essential claim on appeal, same essential claim at trial that was later raised on appeal. Here, the trial court had that opportunity. In overruling defense counsel's foundation objection to the November 21st message, the court stated, "She got a message from Massetti Meach. She knows him by that name on her Facebook account." When counsel again objected to this message, the court stated, "Overruled. She knows the defendant by the nickname of Massetti Meach, whatever it is, a nickname or otherwise. She got a text from him that day on Facebook or whatever, and that's what he supposedly sent her." So as his comments show, the court was well aware that defense counsel was challenging the lack of foundation for the messages. This court should follow the appellate court's finding that this issue is fully preserved. The state, at multiple points during its argument, mentioned that the standard under Rule 901 is a rational basis standard. However, this court has never said that has never held that the standard under Rule 901 is a rational basis standard. And federal courts who have looked at the federal counterpart to that rule have concluded that it is a preponderance of the evidence standard. And that comes from the United States Supreme Court's decision in U.S. v. Huddleston, where the court said that in order to make out a showing that the matter in question is what the proponent claims to be, the proponent needs to present evidence, needs to show that by a preponderance of an evidence. So the standard is much higher than the rational basis standard that the state says is applicable to Rule 901. The state also says that the concerns associated with social media are no different than any other thing, anything else, like a letter or anything, which just based on the proliferation of fake accounts, I mean, we're talking about 5 billion fake accounts. To say that that's in any way comparable to the instances of letter forgery is a stretch, to say the least. And even in the case of a letter, you would still have to go, you can't just because a letter purports to be addressed from a certain person, that alone is not enough to show that that person sent that letter. There has to be some sort of identifying characteristics of that letter, such as like being familiar with the handwriting or something of that nature, that would then justify its admission. So even in the instance of a letter, where there is a sort of a two-step analysis that's being applied by Rule 901. And the state attempts to distinguish Kent on the basis that in Kent basically the state is saying there was no other evidence other than these messages linking him to the shooting. And that is simply not true. In Kent, the defendant was feuding with the victim. He was seen with a firearm loitering around his house on the day of the shooting. So there was he made statements to certain witnesses that had previously in the day inquiring about the defendant's or the victim's location. So if to draw an analogy to this case, if that evidence had been sufficient to say, okay, well, we know that he sent this, he posted this Facebook message because look, he's hanging around the house, he's feuding with the defendant. The Kent court correctly found that that evidence shouldn't be considered because it ultimately just gets to the question at issue, which is whether or not he committed the offense. It gets into that circular logic. And in addition, the state says that there's no evidence directly linking the defendant in Kent to his account. but there was a photo of the defendant on the Facebook page. The Facebook page was in the name of, Lorenzo Lucky Santos. The defendant's first name was Lorenzo, and I believe there was evidence that he went by the nickname Lucky. So to say that there was no evidence connecting the defendant in Kent to the Facebook account is certainly inaccurate. The state also says that these messages were sent, mere days after the account, but the November 8th after the alleged incident at the complainant's apartment. But the first message was not sent until 5 days after. The second message was sent 18 days after. I mean, we're clearly dealing with a sort of, acrimonious relationship. People most certainly heard about this incident, or heard that they were having issues between the two of them, and anybody who was maybe sympathetic or to the complainant or had a grudge against Mr. Brand could have been motivated to send the messages. As to the point about whether the state is required to negate, every possibility of fraud, no, the state is not required to negate every possibility of fraud. I never intended to suggest otherwise. But here, they haven't negated really any possibilities. They've just presented such a small showing that it's not as if there's a question of going through and finding specific people and saying, oh, they didn't send that. There's a wide, because of how meager the showing was, there's such a wide range of possibilities of who could have sent these messages or how these messages could have come about. And then just briefly as to the issue about whether the state was required to prove an intent to permanently deprive in order to sustain a conviction for PSMV, the state correctly notes that, when the state does not dispute that when the defendant is charged with possession of a stolen motor vehicle and the evidence shows or the state alleges that he was personally responsible for the theft of the vehicle, that in that circumstance, the state would have to show an intent to permanently deprive. The state does not dispute that point. They only dispute whether that's also applicable when there is this question of conversion. Now, the state says that there are, stolen and conversion provide two distinct legal theories for proving a defendant guilty of PSMV. They even go so far as to attempt to distinguish People v. Pollards, upon which Brand relies, on the basis that the prosecution in that case relied solely on a theory of possession of a stolen motor vehicle. But the same is true here. The state never once mentioned the word converted at trial. Their theory was always that Brand had stolen the complainant's car. And just briefly, I would note that the Illinois Pattern Jury Instructions 23.36, the committee note, directs that when a defendant is charged with possession of a stolen or converted vehicle and it is alleged or the evidence shows that he participated in the actual taking of the vehicle, it may be necessary to include the phrase intent to permanently deprive in the issues, definitions and in issues instructions. So that's not drawing any distinction there between stolen or converted for the purposes of an intent to permanently deprive. In Pollards, the court found that the may be necessary language refers to situations like the one presented here where the defendant is alleged to have personally taken the vehicle. It would also create this sort of illogical situation where it would be conflating PSMV with criminal trespass to a vehicle, which does not require the offender to have taken or intend to have taken another's vehicle for any specific amount of time. The state could then there would be no point for the state to ever charge possession of a stolen motor vehicle when, according to their own position, they could secure a conviction under possession of a converted motor vehicle theory much easier. And in light of the evidence presented at trial, specifically that according to the state's own theory, Mr. Brand returned the car, there's no showing of an intent to permanently deprive here. For all these reasons, as regard to the Facebook issue, this court should reverse Mr. Brand's convictions for home invasion and PSMV and remand for a new trial. And then in regard to the PSMV issue, this court should reverse his conviction outright. Thank you, Your Honors.
Thank you, Mr. Vennick. Case number 125945, the State of Illinois versus Corsetti Brand, known as Agenda Number 2, will be taken under advisement. We thank you, Mr. Sonnenfeld and Mr. Vennick, for your argument